My name is Stephen, and today I'm giving my advice on one of the most important, but often disregarded legal documents, power of attorney. We tend to focus more about wills as we become older, rather than appointing someone we trust to function as our attorney. Many people put off obtaining power of attorney until the last minute, which can lead to coercion or manipulation when family members become involved. I have been through the power of attorney process where I had to actively use my powers to protect my dad and his estate from abuse and fraud by a family member. I am not a legal advisor by any means. I care about what's happening to the elderly. I'm concerned at what I've seen in adult safeguarding and have begun my own channel to help me seek accountability for those involved, seek justice for my dad, and be a voice for the elderly. I hope you find the advice informative and helpful. Understand the power. Make sure you fully understand the powers that you are granting. Why put it off? It's pointless to wait until you have memory problems before granting someone power of attorney. Your welfare attorney will have complete power over your welfare, and even where you live. Financial power of attorney grants your attorney complete access to and control over any assets you own. Consider your options. In the UK there are mostly two different types of power of attorney, including ordinary power of attorney and the more popular lasting power of attorney. In Scotland, where I have my experience, there are generally three types. Welfare power of attorney gives powers to make decisions around health or personal welfare matters. Welfare powers may only become active after the power of attorney has been registered with the Office of the Public Guardian and when you have lost capacity to make decisions on matters to which the powers apply. Continuing power of attorney gives powers to deal with money and/or property. Continuing powers can be used by the attorney immediately after the power of attorney document has been registered with the Office of the Public Guardian. If you wish the power of attorney to become active only on the event of your incapacity, it must clearly state this and give details about who should make this decision about your capacity. Combined power of attorney. The majority of power of attorneys registered in Scotland are a combination of welfare and continuing powers. It is important to understand what you are trying to accomplish with a power of attorney and then make certain that you have such a document crafted for that purpose. Choose wisely. This can't be overstated. You are appointing someone to make all your business, financial, and medical decisions for you. It is important that you have no doubt in the ability of that person to perform honourably in any areas for which you give them authority. If you have a child that has made poor financial or personal decisions, don't give them the opportunity to make similar poor decisions on your behalf. You must trust them. I get asked all the time, can an attorney steal my money? Unfortunately, the answer is yes. Your chosen attorney will have full access to your financial accounts and can use them for their own benefit. There is a code of conduct, and attorneys have a fiduciary duty to use your assets for your benefit, and not theirs. Trying to recover stolen or misused funds will be almost impossible if the attorney has spent the money already. The power of two. Consider naming more than one power of attorney. While having more than one attorney can bring its own problems, in my opinion, it is well worth the effort to have an extra set of eyes monitoring the use of power of attorney. Having more than one attorney, in my experience, can greatly reduce your risk of elder and financial abuse. This is an important decision, but it can help to ensure that your assets go to the people that you have named in your last will and testament. Name a substitute. If you decide on a sole power of attorney, a substitute is a good idea. Something may happen to your attorney, resulting in them having to resign from acting on your behalf. A named substitute attorney can seamlessly take over power of attorney at short notice. Also, consider nominating a guardian in your power of attorney in case one is needed down the road. Abuses are common. A fraudster who posed as his elderly victim's grandson in a £188,000 fraud has been jailed. The 85-year-old victim, who worked his entire life for the savings, died a year after being targeted and never saw justice. The dad of two siphoned £188,397 into his own nationwide account in 4 branches over consecutive days. A carer cruelly set up online banking facilities for the accounts of two vulnerable women she was looking after and used it to steal their money, a court has heard. The victims, who are in their 90s and have dementia, and who do not use the internet, were completely unaware somebody was accessing their accounts. The thefts only came to light when the family of one of the victims noticed withdrawals from her account which she could not have carried out, and alerted the firm that the carer worked for. Police were then contacted, but the defendant denied doing anything wrong, despite the login details for one of her client's bank accounts being found at her home. The number of fraud cases in UK courts doubles in a year as the pandemic allows scammers to target people in their own homes. More than 150 alleged fraud cases appeared in court in the first 6 months of 2021. This was compared to just 76 in the same time period last year. Victims are trying to claim back £43.1 million in stolen money. If it is discovered that your power of attorney abused their position and has taken money from you, it can be difficult to recover all the funds. It is important to appoint someone that you trust. If you suspect that someone is abusing the power of attorney, then you need to act quickly to cut off their authority before they do more damage. Better safe than sorry. You still have power to act. Appointing someone to act on your behalf does not prevent you from acting on your own behalf. If you still have the capacity to make your own decisions, then it is important to recognize that you still have the right to do so. A power of attorney does not remove your power to act. It just authorizes someone else to also act under the limitations that you have placed. Power of attorney is fully revocable. A power of attorney is always able to be revoked or amended. As long as you have the capacity to make appropriate legal decisions on your own behalf, then you have the right to make changes to your power of attorney document. If you do not believe that the document is in keeping with your wishes, then you should certainly consult with an attorney about how to get the document changed to reflect those wishes. Power of attorney v. last will and testament. I often hear from people, unsure of who holds the authority, when a power of attorney has been active, yet you already have a last will and testament, and appointed an executor under that document. You don't want to cause confusion about who has the authority to act. Let me explain. Something that most people don't realize is that on your passing, the power of attorney document is no longer valid. Anyone that serves as an agent under a power of attorney should cease all action under that document at the moment of death. If they continue to try and act under the document, then they are putting themselves at risk of facing criminal charges. The named executor of your last will and testament will usually now control what happens to your assets. This transfer of authority can at times lead to family disagreements. However, the named executor will now have the authority to execute the will to meet your wishes. In many instances, we see powers of attorney continuing to act under the document after the passing of the person that appointed them. This is not appropriate and doesn't have legal authority. The will that you have created controls who will act on behalf of your estate when you pass away. This person does not have any authority to act until you have passed away, and the court appoints that person to act on behalf of the estate. Something for both parties to be aware of. This warning is twofold. Firstly, if you are creating a power of attorney, please be careful about what it covers and whom you appoint. Secondly, if you are appointed as an agent under a power of attorney, be careful to respect the strict reading of the document. At times, it is very easy to unintentionally get yourself in trouble through the use of a power of attorney. The guiding North Star for any agent should always be to act solely in the best interests of the person who granted the power of attorney. You cannot use the power of attorney to provide any benefit to you. And finally, read the document. This seems obvious, but clients often do not read their documents. Review the powers listed in the document. Although most power of attorney documents have similar powers listed, you may wish to add some additional clauses that may be more specific to you. For instance, you may wish to add a clause stating that any attorney acting on your behalf shouldn't be left out of pocket for doing so and can claim the expenses from the estate. Most power of attorney documents granted go smoothly, but the rise in vascular dementia and elder abuse is one that we should all be concerned about. I hope that I have managed to answer some of the questions that the growing number of family members who are caring for their elderly parents or anyone contemplating making arrangements for their later years are needing answered. Before I go, I would like to say thank you for finding the video interesting enough to watch till the end. Due to my investigations into adult protection, I'm driven to be a voice for the elderly and to seek justice for my dad. You can help my voice become louder by subscribing to my channel, and I would be so grateful if you could like and share the video as far as you can.